Welcome to my channel for the Hindu editorial analysis of August 17. If you like my video, do hit the like button, subscribe my channel and also give your opinion about the video. And for those Tamil viewers, I would like to tell that the editorial analysis in Tamil of August 15, 16 and 17 will be uploaded by me today. I'm sorry for the delay guys, Anna. I will upload it within today night. So the article which we are going to see today is the health checklist. See, this article is all about the medical infrastructure in India and especially with respect to the Uttar Pradesh. So we'll look at this article, and even this article, that is the architecture of censorship. Even this article is all about freedom of speech. We will look this article in detail. Plus, I will give you certain points in this article with respect to the examination. And the third article which we'll see today is naming a right. This article is all about the right to privacy. So we'll look at this article too. And the rest article, that is Trump's misstep and reading Kim Jong-un's mind. These two articles are not important because we will not see these two. Fine. So let's move to the article. So coming to the first article, the health checklist. This article mentions that in India, the rural health system is very weak. And there is also an extraordinary patient load in few hospitals, as this could be seen in Gorakhpur. See guys, we could have seen before 2 days that in Gorakhpur, many children have lost their life due to Japanese encephalitis, plus the lack of oxygen supply to the hospital made the situation worse. And now what happened is, many patients in and around the hospital, that is, even patients around 60 kilometers from the hospital are moving in towards this Gorakhpur hospital because of the lack of infrastructure in their area. So a situation of medical infrastructure crisis is prevailing in Uttar Pradesh. As the article mentioned, the institution has come under the spotlight after the report of death of several children over a short period. Even though Uttar Pradesh have epidemics and a high mortality as a chronic feature, the medical infrastructure in the surrounding areas, districts of this hospital is so weak that a large number of sick patients are sent to the Apex hospital as a last resort. Plus, the article also tries to bring in a report of CAG saying that this dysfunctional aspect of rural health system is also shown in the CAG's report on reproductive and child health. And this report claims that there is a lack of financial administration, and even this, when ignored, there is an inability to observe the funds allocated. There is a shortage of staff at the primary health center as well as in the community health center. Plus, there is a lack of essential medicines. Plus, the equipments are not up to the mark, that is broken down equipments. Plus, unfilled doctor vacancies. See guys, you could use these points as a shortcoming if at all you write such answers with respect to the health system which is prevailing in India. And the article mentioned, in case of Uttar Pradesh, the CAG is founded that about 50% of the primary health centers do not have a doctor. And this is not only in Uttar Pradesh, it is also in many states, as the article quote the number 13. So it says that in nearly 13 states, there is a significant level of vacancies with respect to the doctors availability, as basic facilities in the primary health sector and even in the community health sector is met only half the need in Bihar, Jharkhand, Sikkim, Uttar Pradesh and West Bengal, which also put pressure on an handful of referral institutions such as Gorakhpur Hospital. See guys, it is obvious, if there is a lack of medical infrastructure in the rural region, then the people will tend to move to those hospital which is famous or which has a good infrastructure. So as in the case of Uttar Pradesh, it is Gorakhpur. Plus, the article say templates for this rural health system have been finalized long ago. That is, the roadmap for this rural health system has been finalized, and even the public health standard were issued in 2007 and 12, which covers many dimensions. The article also mentioned the center has set many ambitious target and it has an ambitious health goal for the 2020 and also have been financing many health projects. One such is the National Health Mission, which aims for a reduction of infant mortality rate to 30 per 1000 live births from the recent estimate of 40. And for this to be achieved, it will require an investment and monitoring mechanism ensuring that there is a prescribed standard of access to a health facility. Plus, there should be a medical and nursing source within a 3 kilometer radius. So, if we need to achieve an infant mortality rate to 30 per 1000 live births, then we need need to have an hospital at least in a 3-kilometer radius according to this article. Fine. Plus, the article also mentions that it is also important for the government to recognize the limitations of market-led mechanism. See guys, the medical infrastructure in India even can be achieved with the help of privatization. So the government needs to work on that. Plus, the Niti Aayog has also pointed out that the health should be considered as a public good. If it happens to be a public good, then the health service should be given at an affordable price. So there should be a cost control that make efficient purchase of the health care from private and public hospitals. So as a end note, the article mentioned we should bring in equity in access to the doctors, in access to the medical infrastructure for the rural population especially, and there should be given a priority under this National Health Mission. Okay, fine. And guys, here I would like to make a point. See, from this article, you can bring up the shortcomings which is present in our health system and especially with respect to the rural India. So you could write there is a lack of medical infrastructure facility and more people are concentrated towards a famous institution because of this, and there is a lack of financial administration, shortage of staff, shortage of doctors, unequipped hospitals, even equipments are not up to the mark. So these are the shortcomings, and what I want you to do is you just go through the National Health Mission of India. Fine. I've also taken a video on National Health Mission. I have given you link in the description box. So you just go through what is the National Health Mission in India and what are the objectives and the aim of this National Health Mission. Plus, recently the Niti Aayog has suggested that the district government hospital can be outsourced, that is a part of district hospitals can be outsourced to private medical institutions in order to tackle with the infrastructure deficiencies and in order to treat non-communicable diseases. So even you could add these points with respect to the health system. And the question which you can expect with respect to mains is that what is national health policy and whether the national health policy addresses the present scenario prevailing in our health system. Or the question can be, what is the objective of the national health system? Bring out the status of the health systems which is present in India and what could be the solution to mitigate the deficiencies. Fine. So you could expect these sort of questions in the mains examination. Fine. So let's move to the next article. So coming to the next article, the architecture of censorship. See guys, this article is all about right to freedom of speech and expression, and the article tries to explain it with two examples, that is with respect to the books which were banned. So what we'll do is we'll look at the introduction and this example in a crux format, then we'll move on to the conclusion. Plus what I will do is I'll give you another issue which is prevailing with respect right to freedom of speech and expression. Fine. So here the article mentions that an Independence Day is an occasion to celebrate a freedom from the colonial regime. So by freedom we mean economic and political bondage plus freedom of speech, expression and dissent. See guys, dissent means arguments or opinion which is placed. Fine. So our independence brought in freedom in many forms, and even the article mentions that the demand for a right to free speech and especially with respect to the political, cultural and artistic censorship were at the heart of our freedom struggle. See guys, censorship means a ban on any part of book, films or news, etc. So one could have noticed that the censorship laws during our freedom struggle was very stringent. Even you could write the example of Amit Bazar Patrika, even the example of Tilak. So one could notice that this freedom against censorship was very much needed in order to place an opinion. And it is because after the freedom, the Article 19(1)(a) of the Constitution was provided to us, which ensured right to freedom of speech and expression. And the article mentions that last week few incidents showcase that this freedom of speech and expression is fragile. That is, this right to freedom of speech and expression still have certain shortcomings, especially when it is against the authority of the states. So the examples which the article gives is the Jharkhand government's decision to ban a book which is called The Adivasis Will Not Dance. So this was the book which was banned by the Jharkhand government, and the plight here is the writer happens to be a Sahitya Academy winner. So this book was banned, and even a civil court at Delhi, that is at Kakar Doma, has banned the sale of a book titled God Man to Tycoon. So this book was on Baba Ramdev. So even these two books was banned. And the first book, that is the Adivasi Will Not Ban, was all about the Santal community who are living in Jharkhand and in and around the states of Jharkhand, which showcase they are in a terrible situation. As the article mentioned, these sort of incidents, that is banning the books, is not a solution to this issue. Rather, it opens up a debate. It opens up a prolonged battle over the freedom of speech, and which could bring in a sense that the freedom of speech is not provided to us in an appropriate manner, as it has an uncertain outcome. Plus, these sort of incidents also reveal that the censorship exists in India to a greater extent, and it is very easy to apply this censorship because of two reasons. One is because of the structure of the Indian legal system. That is, the Indian legal system is structured in a manner where applying censorship is almost costless, and it can be tried by any state governments or anyone who is in authority. And the second thing is that the only counteractive to this censorship which is present in India is a strong judicial commitment to free speech, which is not existing at all the levels of judiciary. So one could see that the censorship is applied freely at no cost, plus there is no counteractive action which is available to the person who is involved rather than going to the judiciary. So these two scenarios clearly shows that an environment with respect to the freedom of speech in India is almost in a danger, where the writers, publishers are facing the threat and they face a lot of hardship because of this. And guys, this article also talks about the Jharkhand ban in detail. It says that the Jharkhand government bans on the Adivasi which will not dance is after a public protest in Jharkhand with even an MLA calling for a ban for it. And why there is a protest is because this book involved an insultation against a Santal woman, and because of this reason the book was banned. So the article tries to bring in few provisions of law. It says that section 95 of Code of Criminal Procedure authorize the state government to forfeit copies of any newspaper, books or documents that violate certain provisions of the Indian Penal Code. That is, if any books violate, see, it is not only book, if any text or any newspaper items, if it violates section 124A, that is the Sedition Act, and even section 153A, that is communal or class disharmony, and section 292, that is insulting religious belief. So if any action which is against this section, then the government can go in for ban of this book with the help of section 95 of Code of Criminal Procedure. And the important plight to be noted with respect to this section 95 is that this section 95 allows the government to ban without having to prove before a court. So it is a sort of discretionary power which is available to the state government. And with the view of writer, he has only one way to go against this, and that is to go for a trial in court. So the article mentioned the Code of Criminal Procedure has been structured in such a manner that it is detrimental to the interest of free speech, which gives the government a discretionary power to ban the publication with a stroke of a pen. So it is a piece of over-regulation, and it is a piece of even abuse to the writers who have gone through many difficulties in writing a book. Now coming to the next example, that is the Doma injection. So here a civil court has banned a book which is called as God Man to Tycoon. Now here the court has mentioned that the book had given a cursory reading, that is an indifferent reading and a different interpretation of the reading, and also have examined the specific provisions of a court trial of Mr. Baba Ramdev, which happens to be a defamatory cases, and it is on the basis of this defamation the court has banned the publication and the sale of the book. And in this case one could notice that the court has implied this section 95 of this Code of Criminal Procedure Act, and one could also notice that this book is banned without an hearing. So it will be in continuation to ban until the other court lift this verdict. And once again one could see here that it is the writers who have been attacked, and one could also notice that the court has also not provided for any monetary damages to these writers. So what the article tries to say is, in these sort of cases the court can go in for many trials and could have analyzed this issue in deep, and if they have finally proven that these books contain defamatory cases, then they could have banned it. But this was not happened in this case. And this article also tries to bring in a case of 2011, that is the High Court of Delhi has observed that if at all any case comes in with respect to the freedom of speech and expression, then the perception should be that this freedom of speech and expression should be given favorism. And this case, that is the Doma case, is against this according to this author, and it is also particularly unfortunate. So the article as a solution tries to say is that the first problem with respect to this issue is the legal problem. That is, one needs to repeal the section 95 and 96. That is the power to ban the book, and it should not give power in the hands of the government or even court to an extent. So a mechanism to this could be one should have a clear analysis and a greater evidence with a warrant for a ban. And the other solution is that we have a tendency of unapologetic affirmation. That is, we always tend to neglect the expression which is against us. That is, we do not take criticism. So this scenario should be addressed, and it could not be addressed with the help of the law, but one needs to change his or her attitude, and it should be a core foundational and non-negotiable value which should be presented in our constitution. Fine. So that's it with respect to this article. And guys, before 10 days, there was also another case similar to this. That is that the Karnataka government sentenced a person to jail with fine because he wrote some defamatory article against the state government. So even there was a breach of freedom of speech and expression. And this case there was, he wrote defamatory article against the speaker and the member of legislative assembly of the particular Karnataka assembly. So even there one could sense that the state is using force against this freedom of speech and expression. See, there the government did not ban the newspaper, rather they went in for an act that allowed for imprisonment up to 2 years. Fine, even you could correlate that issue with respect to it. And the solution to these could be there should be a proper codification of the law. One needs to analyze what is the breach of freedom of speech and expression. See, for this freedom of speech and expression, we have reasonable restriction. Even though we have reasonable restrictions, freedom of press and restrictions for the freedom against censorship is not codified, which allows for different interpretation in different cases. You can also see the example of Asim Trivedi. So the solution to these could be there should be a proper codification of law, and it is the right time for the Supreme Court to bring in these codification. Plus, the center can also amend laws for this reasonable restrictions for the freedom of speech and expression. Plus, from this article, you could also infer that the section 95 and the 96 of this criminal procedure, that is the Code of Criminal Procedure, should be abolished, as it gives power to ban the books without any trial. Fine. I hope the concept is clear. And for the UPSC mains, you could get a question that the freedom of speech and expression is provided to us by the Indian Constitution, but it is now under a several criticism. Present your views with different exams. So you could get the questions in such a way that UPSC will tend to ask you from basics, combining it with the current events. So this is the idea which I want to give you. You read any article, UPSC has a tendency to ask questions from the basic, combining it with the current events. So as in the case now, we saw censorship and a newspaper ban. So you could write these two issues with respect to the right to freedom of speech and expression. And if you have more examples with respect to right to freedom of speech and expression, please write it down in the comment box. Fine. So let's move to the next article. And the next article is naming a right. See guys, this article is all about right to privacy. See guys, I'd like to mention a point here. The right to privacy word is not mentioned in our Indian Constitution. But this right to privacy is an implicit right according to the Article 21 right to life of our Indian Constitution. It is an implicit right because many verdicts of the Supreme Court judgment have forecasted so. And I'd also like to make one more point. This right to privacy has many dimensions. It does not have only one dimension, but it has many dimensions. See, the right to privacy could be with respect to the breach of space, with respect to the breach of identity, with respect to the breach of information, with respect to the breach of data. Even we have a privacy not to speak. So there are many dimensions for right to privacy, and this codification of right to privacy is very difficult. So one could infer that this right to privacy can be analyzed by case to case basis, that is with the help of the verdicts of Supreme Court. And guys, I have taken this right to privacy with the background in a separate video. I have given you link in the description box. You can have a go through. Fine. So coming to the article say a 9-judge bench headed by a Chief Justice determining whether this right to privacy is a fundamental right or not is the 15th time in these. So these 9 judges will definitely shape an evolution of a constitution. That is, they will try to bring in a clear picture with respect to the right to privacy. privacy. And the thing which is at stake is the fundamental relationship between citizens and the state. See guys, this article tries to talk about the Aadhaar card. See, I hope everyone knows about Aadhaar card, which happens to be a biometric card which have personal information about us. That is, Aadhaar card has information of our name, gender, age, etc. Plus it has our iris scan, even a thumb impression. So these biometric data added with many informations such as PAN card, bank accounts make Aadhaar an significant tool and a source of our information. Now the question is whether government using these details is a breach of right to privacy or not. And the article mentions when Aadhaar was initially challenged in 2015, the union government argued that we have no right to privacy. So this does not bring out a clear response, because see, one cannot argue that we do not have a right to privacy, right? So now a better argument is put forward saying that this right to privacy must not be declared because it is an expansive right without clear boundaries. So there is no proper demarcation of this right to privacy. As we saw before, the right to privacy has many dimensions, and the union government also argued that there is no need for us to declare this right to privacy as a separate right because we already have Article 21, that is the personal liberty, which covers this right to privacy. And now this article is related to this. And the article tells that in the year 1950, the court had displayed a commitment towards this Article 21, that is right to life, and also showcased that this right is a basic right, and it also guaranteed that this right to life includes right to food, shelter, education, health and environment. But one could sense that it is a narrow interpretation because the dimension covered are only with respect to the food, education, health, environment. So this is a narrow interpretation according to this article, and there is a need for us to expand this, and we always tend to welcome the expansive right. Plus the article also mentions that all constitutions in the world, including India, have the tendency to maximize the citizens' right and freedoms, and they generally tend to restrain the government's capacity to curtail them. And even in India it is the same case, where we have followed the same path, that the fundamental rights should be defended by our courts, and in order to prevent the breach of fundamental rights, we have a mechanism which is called as court. Plus the article tries to brings in different interpretation with respect to the right to privacy. It says that if you take right to privacy, then its understanding is important because the personal liberty, as mentioned in the constitutions, has many interpretations. But at the same time, if you look into the constitution, the basic features such as torture, that is right against torture, is not provided by our constitution. That is, the dimensions are not covered. And the Supreme Court in 1980s in Justice Krishna Iyer case said that this right against torture is also a fundamental right. So as in the 1996 in D.K. Basu versus State of West Bengal, the court finally acknowledged that torture might have been acceptable historically, but it is no longer conceivable in law or morals. So with this, we can also go against the claim of the police by giving it name the torture. Fine. So the right against torture, and declaring that it comes under Article 21 of our Indian Constitution, personal liberty. Now, even this torture has different interpretation. See, this torture can be in the form of physical torture, and even it can be in the form of mental torture. Fine. So the Supreme Court in 2010 observed in the Selvi versus State of Karnataka that the torture not only includes physical torture but also mental torture. Plus, even with respect to the right to freedom of speech and expression, that is under Article 19(1)(a) of the Indian Constitution, does not mention the word freedom to press. But the Supreme Court has also observed that this freedom to press is implicitly covered under this Article 19(1)(a) of the Indian Constitution, which we saw earlier in the before article. So the article mentions, even though freedom of press is there are also reasonable restrictions for it. At the same time, the court has mentioned that this right to privacy is a fundamental right, and this right to privacy implicitly mentions that the privacy in various forms. So the central government argument that the various dimensions of this right to privacy is not demarcated, and because of this right to privacy is not a fundamental right, is inappropriate according to this article. See, if we have right to privacy, then we know we have a basic sense of what the right to privacy is, and we also know that this right to privacy is a fundamental right. So we can go in an argument that this could be a breach of privacy. Fine. Plus, one could also infer that the dimensions of these right varies. See, we saw an example. First, we saw an example of torture, but later we added that even mental torture is right against torture. Fine. So different interpretations are there according to the time frame. It keeps on changes. As the article say, even this right to privacy has a wide range of things. For instance, preventing the state from watching us, or in choosing our identities, or to decide what information should be provided by the state or should be collected by the states with respect to us. And each one of us has different opinions with respect to right to privacy. And it is this objection which puts a burden on the state to bring out the instructions. That is, to bring out a proper demarcation with respect to right to privacy. As the article mentions, naming and declaring a right has powerful consequences, because recognizing the right is the first step in opening up the position trickling down into people consciousness. That is, it could make a sense to the people that it is their own right, and it could bring in a sentiment against the government. But the article mentions, as the government and technologies are becoming intrusive, that is, they are trying to probe into our personal matters, then the people of this country should be empowered with this sort of rights. And the article say that it is upon the 9-judge bench who will decide upon the case with respect to each and every person in India which has issues involved to the core of a personal liberty. Fine. So this year you could expect a question in mains with respect to this article. For sure. That is, this right to privacy has been in the news for many times. That is with respect to breach of Aadhaar. That is with respect to the Aadhaar card and many other dimensions. So the possible question could be, what is right to privacy and what is the present scenario with respect to it? Or what is the status of right to privacy in India? Bring out with examples. Fine. So this could be the article. So that's it for today, guys. Thank you. Thank you for watching.